Two tariff actions, signed weeks apart by the same administration under the same section of the same trade law. One of them got sued within hours of taking effect. The other one, the one aimed at Canada, the one legal researchers have called the more vulnerable of the two, has not been challenged in court at all, not once. And the silence around that fact is more interesting than the lawsuit itself. If you have been following this channel, you already know the outline. In this video, we are going to compare the two head-to-head, show you exactly who sued and why, explain why the Canada tariff is widely considered the easier legal target, and walk through the most likely reasons nobody has pulled the trigger on it yet. Subscribe to PowerMap and turn on notifications, because this is exactly the kind of gap in the coverage that tells you more than the headlines do. Let us start with the lawsuit that did happen, because it sets the baseline for comparison. On July 24, 2026, at 1 minute past midnight, the tariffs on 60 economies under Section 301 of the Trade Act of 1974 took effect, justified on forced labor enforcement grounds. Within hours, two American small businesses filed suit in the United States Court of International Trade in New York. One was Burlap and Barrel, a small online retailer specializing in single-origin spices. The other was Collective Horology, a California-based retailer and distributor. Their argument was not that forced labor is acceptable or that enforcement is unimportant. Their argument was narrower and more technical, and it is worth understanding precisely because it is the exact kind of argument that tends to succeed or fail in front of a judge. They claimed the government failed to establish country-specific connections between each individual country's forced labor enforcement record and any actual burden placed on American commerce. In plain language, the tariff treated 60 countries as one undifferentiated block rather than proving the case against each one individually. They also argued that Section 301 has historically been used to target specific nations and specific industries, one at a time, and that applying it broadly across 60 economies simultaneously has no precedent anywhere in the statute's history. There is a detail about the timing of this specific tariff that makes the speed of the lawsuit make a lot more sense. The 60 economy action did not take effect on a randomly chosen date. It took effect at exactly 12:01 in the morning on July 24th. The same precise minute that a separate temporary tariff authority under Section 122 was set to expire. Section 122 is a balance of payments provision that had been propping up an earlier round of tariffs on a short-term basis. The administration timed the new 60 economy action to begin at the exact instant the old one lapsed, so that Washington's overall tariff revenue and coverage never actually dipped, even for a single minute. That kind of precise handoff between one legal authority and the next is not an accident. It reflects a White House that is actively managing a portfolio of overlapping tariff justifications, ready to swap one out for another the moment it expires or gets struck down, a pattern we have already seen once this year when the Supreme Court eliminated the broader emergency powers tariffs and the administration pivoted straight to Section 338 for Canada within weeks. That is a real legal theory, filed by real plaintiffs in a real court within hours of the tariff taking effect. Small businesses do not typically move that fast unless they believe they have a strong, ready-made argument and a genuine, immediate financial reason to act. Now let us turn to the other tariff action, the one aimed specifically at Canada, and this is where the comparison becomes genuinely strange. On July 20th, 2026, 4 days before the 60 economy action, the administration signed 3 separate proclamations under Section 338 of the Tariff Act of 1930, imposing an additional 50% duty on Canadian motor vehicles, dairy, and alcohol, covering close to $20 billion in trade. This was the first time in American history Section 338 had ever actually been used to impose a tariff. Not since the 1940s has anyone even invoked it. It has no implementing regulations. There is no modern court decision anywhere that tells you how a judge is supposed to interpret it. Legal researchers, including analysts at the Congressional Research Service, have specifically flagged that the statute's own structure implies a president may need a formal finding of discrimination from the International Trade Commission before acting, and no such investigation was ever conducted here. A separate and equally serious argument holds that Section 338 was effectively superseded decades ago by more detailed, more procedurally rigorous trade law passed in 1962. Sit with that comparison for a second, because it should feel backwards. The 60-country action, built on a statute that has been used continuously for decades and has an actual body of precedent behind it, got challenged in court almost immediately. The Canada-specific action, built on a statute nobody has used in 77 years, with a missing procedural step that legal researchers have openly questioned, with no implementing regulations at all, has drawn no lawsuit whatsoever as of this recording. If you were simply ranking these two tariffs by how vulnerable they look on paper, most trade lawyers would tell you the Canada action is the weaker one, the one more likely to fall apart under scrutiny. And yet it is the one nobody has touched. So why? Let us walk through the most plausible explanations, because there are several and they are not mutually exclusive. The first explanation is simply standing and timing. A lawsuit needs a plaintiff who can show real, concrete, immediate financial harm, and ideally one whose harm started the moment the tariff took effect. The 60 economy action covered 99.4% of American imports on day one. Everything, everywhere, all at once. That guarantees an enormous pool of businesses feeling the exact same pain on the exact same morning, which makes it easy to find motivated plaintiffs fast. The Canada tariffs, by contrast, do not take effect until August 19th. As of today, nobody has actually paid $1 of this specific 50% duty yet. There may simply be no plaintiff with completed, provable financial harm to point to. Lawsuits challenging tariffs generally wait for the tariff to actually bite, not for it to be scheduled to bite in the future. The second explanation is strategic patience. Trade lawyers who specialize in this area know that courts generally will not rule on a hypothetical injury. Filing a challenge to the Canada tariffs today, before the effective date, risks a judge dismissing the case as premature, not ripe for review, technically speaking. The smarter legal move, if you are an importer planning a challenge, may be to wait until August 19th, let the tariff actually apply, document the actual financial harm on the actual invoices, and then file with a much stronger, much harder to dismiss case. If that is what is happening, we should expect to see filings appear very quickly after the deadline passes, not before it. The third explanation is coordination. Filing a major constitutional or statutory challenge against a novel use of presidential tariff power is expensive, complicated, and highly visible. Trade associations and larger importers sometimes prefer to let a single, well-resourced plaintiff take the lead, building a coordinated case with the strongest possible legal team rather than having several scattered, weaker lawsuits filed independently that could produce conflicting rulings or a botched early loss that damages everyone's position. It is entirely possible that a coordinated challenge to Section 338 is being built quietly right now, timed deliberately to land the moment the tariff actually takes effect, rather than rushed out early. The fourth explanation is the one worth taking most seriously, and it is less comfortable than the first three. It is possible that Canada itself is holding back specifically because of the ongoing negotiations. Legal action and diplomatic negotiation do not always mix well. A formal lawsuit is an adversarial, public, litigious move. If Ottawa or Canadian industry groups believe there is still a real chance of a negotiated resolution before August 19th, filing suit now could be read in Washington as an act of bad faith, potentially souring talks that are still, at least officially, ongoing. Waiting until the deadline passes and negotiations have either succeeded or visibly failed removes that risk entirely. Under this theory, the absence of a lawsuit is not a sign of legal weakness in the case against Section 338. It is a sign that someone believes the tariff might still be avoided entirely through negotiation and is not willing to burn that option yet. Notice that none of these four explanations require Section 338 to actually be legally sound. Every one of them is compatible with it being just as vulnerable or more vulnerable than the 60 economy action that already drew a lawsuit. The absence of litigation right now tells you almost nothing about the merits of the legal argument. It tells you about timing, standing, strategy, and diplomacy instead, which is precisely the distinction most coverage of this story is not making clearly. There is a fifth, more cynical possibility too, and it deserves mention even though it cannot be proven either way. It is possible that fewer businesses are willing to publicly challenge a tariff aimed specifically at a single named country for reasons that have nothing to do with the law. A lawsuit against a broad global forced labor action is, in a sense, a technical dispute about statutory process. A lawsuit specifically targeting a Canada-focused tariff can be framed, rightly or wrongly, as taking a side in a bilateral political dispute between two governments, which carries a different kind of public and political exposure for the business filing it. Whether that perception actually influences real corporate legal decisions is impossible to verify from the outside, but it is a factor worth naming rather than ignoring. Think about what that timeline actually means for a Canadian-owned auto parts supplier, or an Ontario dairy cooperative, or a small Quebec distillery that exports to the United States. Right now, today, before August 19th, none of them have technically paid the new 50% duty on a single shipment. Their accountants can model the cost, their lawyers can draft a complaint. But until an actual invoice reflects an actual 50% markup, they do not have the same kind of concrete dollar and cents injury that the spice retailer and the watch distributor could point to on July 24th, when their costs changed literally overnight. That is not a small technical distinction. American courts take standing seriously, and a plaintiff showing up with a hypothetical future cost increase is in a meaningfully weaker position than one showing up with last week's actual invoice. Let us also be precise about what has and has not happened on the international side, because this matters too. Canada has an established track record of using the World Trade Organization, having filed disputes there over earlier American tariffs on steel, autos, and agricultural products. As of this recording, there is no confirmed WTO filing specifically targeting the Section 338 tariffs. That process, when and if it starts, runs on a completely different and much slower timeline than a domestic court case, often years rather than months, and it exists alongside any domestic lawsuit rather than replacing it. The absence of a WTO filing so far is less surprising than the absence of a domestic one, simply because WTO disputes are rarely filed as a first fast response to anything. Here is what makes this comparison useful, beyond just satisfying curiosity. It tells you something real about how tariff law actually gets contested in practice, which is different from how it gets described in headlines. Headlines tend to treat every new tariff the same way: announced, controversial, presumably headed for court. The reality is that litigation timing depends heavily on who gets hurt first, who can prove it, and who has the resources and motivation to move quickly. A tariff that hits everyone immediately, like the 60 economy action, generates instant plaintiffs. A tariff with a future effective date, even one built on shakier legal ground, can sit unchallenged for weeks simply because the clock has not started yet. That distinction matters for anyone trying to predict what happens next in this trade war, not just this specific pair of actions. If you are watching for the moment a legal challenge to Section 338 actually appears, the date to watch closely is not today. It is August 19th, and more specifically, the days immediately following it, when Canadian imports actually start absorbing the 50% duty and businesses can point to real invoices, real losses, and real standing to sue. So here is exactly what to track from here, because these four things will tell you how this specific gap closes. First, watch the days immediately after August 19th for a Court of International Trade filing specifically targeting Section 338. If the standing and ripeness theory is correct, this is when a challenge should appear, and it may come quickly, since the legal arguments, the missing International Trade Commission investigation, and the implied repeal question have already been fully worked out in public commentary for weeks. The legal team filing it will not need to build the argument from scratch. Second, watch how the Section 301 lawsuit filed by Burlap and Barrel and Collective Horology actually proceeds. If a judge rules quickly and favorably for the plaintiffs there, expect that ruling to accelerate a parallel challenge to Section 338, since a win on one novel tariff theory makes lawyers considerably more confident challenging the next one. Third, watch the negotiating table itself between now and August 19th. If talks visibly collapse before the deadline, that removes the diplomatic incentive to hold off on litigation, and a lawsuit becomes considerably more likely to appear even before the tariff formally takes effect. Fourth, watch for signs of a coordinated, well-funded challenge being assembled quietly. Industry association statements, joint filings, multiple plaintiffs appearing together rather than one small business acting alone. A coordinated filing landing the moment the deadline passes would tell you clearly that this was a deliberate strategic delay, not a sign the case was weak. One more angle worth considering before we close, because it cuts against the tidy version of this story. It is entirely possible that a lawsuit is being prepared right now, quietly, by a law firm that simply has not filed yet, and that within days of this video going up, a challenge appears and this entire comparison becomes outdated. That would not make the analysis wrong. It would confirm one of the very explanations already laid out here: standing, timing, or coordinated strategy. The value of walking through this gap is not in predicting the exact day a lawsuit lands. It is in understanding ahead of time why the timing looks the way it does, so that when a challenge finally does appear, you already understand what took it so long. Here is the honest summary. Two nearly identical tariff actions signed days apart under provisions of the exact same section of trade law have produced two completely different legal outcomes so far. One drew an immediate, well-organized lawsuit from small businesses within hours. The other, widely considered the more legally exposed of the two, has drawn nothing at all. That gap is not evidence that the Canada tariff is legally sound. It is evidence that litigation timing runs on standing, strategy, and diplomacy, not simply on how strong or weak an argument looks on paper. And it means the real test of Section 338 has not actually started yet. It starts on August 19th, when the tariff stops being a threat on a calendar and becomes an actual cost on an actual invoice. It is also worth remembering that this entire comparison sits inside a much bigger story we have already been tracking on this channel. The same administration that revived a 1930 statute nobody had used in 77 years, the same one that timed a new global action to the exact minute an old one expired, is clearly operating with a deep bench of overlapping legal tools rather than relying on any single one. Every time a court closes off one avenue, another one opens. Understanding which tool is currently active, which one is being challenged, and which one is sitting quietly unchallenged is not a side detail in this trade war. It is close to the entire story. We are going to keep watching both of these cases closely. The Section 301 lawsuit as it moves through the Court of International Trade, and whatever happens the moment the Canada tariffs actually take effect. If you want trade coverage that tracks the legal mechanics instead of just repeating the announcement, that is exactly why this channel exists. Subscribe, hit the bell, and tell me in the comments what you think. Do you believe nobody has sued over the Canada tariffs because the case is weaker than it looks? Or because everyone is deliberately waiting for August 19th? I want to hear your read on this, because whichever one it is will tell us a great deal about how the rest of this fight plays out.